Hey everyone, it's Justin from Voices for Voices coming to you with a another episode of our show. Thank you for joining us. We're grateful and humbled to have you watching, listening, wherever you are, here in the United States or at all points across the world. We want to say welcome. You've been with us from the beginning. Thank you. If you haven't, we have over 300 episodes in our catalog, so we encourage you to check those out at your convenience. Download from your favorite platform. If you could do us a big favor, give us thumbs up, like, share, subscribe, follow, comment. All those things are very helpful to us, and they don't cost you a dime. So it doesn't cost you a dime. What we're going to be doing today is uh, it's uh, it's come to our attention that uh, a show we did prior where we talked about how Faith and Fantasy Alliance LLC, uh, which is aka Realm Makers, and the leaders of Scott Miner and Rebecca Miner, they made a decision to uh, sue uh, a human trafficking survivor, David Solomon, and Voices for Voices. And and so we want to make sure that the facts are out there because uh, we we believe in facts. We believe in sharing facts. We believe in public safety health, public safety concerns, people being able to tell their stories, uh, all of that with the huge pillar of mental health and trauma and recovery and advocating for uh, the those who have those challenges, like myself, which again, I talk about on many different episodes. So go check those out. We have a packed episode here today, so I'm not gonna get into all that right now. So what I'm gonna do here is see if I can do something a little bit on the quicker side. Okay, so here's kind of the setup. And so just to kind of show that uh, we're given the truth here, we're given facts, legal facts, legal filing. And so again, human trafficking survivor David Solomon, Voices for Voices. We've been sued, uh, and so what we're going to be doing today is we're going to be going through our response. Okay, so you can see here that there's quite a few pages, uh, and so I wanted to show that on the screen, so there's no confusion on what we're sharing, whether it's the legal documentation or not, because we just would we prefer it that way. So in this lawsuit, Faith and Fantasy Alliance LLC et al., which means that there's other terms that come under that, like Realm Makers, uh, Scott Miner, Rebecca Miner. And so again, we're not hiding anything. Court of Common Pleas, Montgomery County, Pennsylvania. So we don't live there, but Scott and Rebecca Miner do, and that's where Faith and Fantasy Alliance LLC is registered. So that's why we're talking about Pottstown, Pennsylvania, and Montgomery County. And this is case number 2025-15709. First and foremost, we do have an attorney. We do have an attorney. So that is thing one. Thing two is we get started. Uh, so let's get started. So in the initial, filing documents, there were, let's see, I don't want to miss anything. Uh, mm, 100, 100, I believe 133 plus different different points, right? So, think of it as, a topic, a question, and then it needs an answer. And that would be topic one. And then another question, wanting an answer, etc. So that's how this is laid out. So what I'm going to be going through is our legal response to these big areas. Um, so here we go. So we had a jurisdiction, Montgomery County, that that's not being contested by us. And so now we get the facts. Okay. So these are facts. So we're gonna get into let's see, let's start on number 12. That's a nice area to start. So number 12 in our response is, quote, admitted in part, denied in part. It is admitted that the listed operations are part of Realmmaker's primary operations are, but it is denied that these are the only primary operations. The rest of Realmmaker's problem, the rest of Realmmaker's primary operations lie in their kidnapping and brainwashing children and young adults while inculcating them into their cult. So you can see there, okay? So that's number 12. That's a biggie. Then we jump to number 15. Admitted in part, denied in part. So that means what it what it says. Uh, it is admitted that defendant Solomon was part of the realm sphere community and that he was making statements about being trafficked by Brian Davis. It is denied that these statements were unsubstantiated as they are true. Let me read that again. Number 15. Admitted in part, denied in part. It is admitted that defendant Solomon was part of the realm sphere community and that he was making statements about being trafficked by Brian Davis. It is denied that these statements were unsubstantiated as they are true. So there are facts that support this indeed is true. Number 16, admitted. By way of further answer, and after years of Solomon's involvement in Realmsphere, it is the strong belief of defendants that Davis, referring to Brian Davis, is not only a member of the Realmsphere social network, but rather one of the leaders of this cult. 17. Averment 17 is a conclusion of law to which no response is required. To the extent of which a response is required, the allegations in Averment 17 are denied. Number 18, here we go. Admitted that communication was made and information was requested from Solomon's wife by Scott Miner, but it remains unclear as to whether Scott Miner ever looked into any of the claims made or information put forth. Number 19, while there's no requirement to respond to an allegation of Scott Miner's intent, it is specifically denied that Scott Miner ever performed any investigation or due diligence into any claims made by Solomon or anyone else as to the abuse taking place inside of the cult of Realm Sphere. By way of further answer, it is specifically alleged that Scott Miner not only knew about the trafficking of Solomon and others, but contributed to it. Number 20. It is specifically denied that Solomon provided any falsified or edited evidence, and further denied that any investigation of merit ever took place by Scott Miner, other plaintiffs, or anyone at Realm Sphere. 21. Admitted in part, denied in part. It is admitted that Solomon's access and account on the Realm Sphere site was removed and prohibited. It is denied that this was a result of any threatening voicemail, but rather the result of Realm Sphere trying to shun Solomon and turn its community slash cult against him. In fact, Solomon has been running away and hiding from this cult since he escaped its control. The last thing he, referring to Solomon, would be doing is calling and leaving threatening emails for anyone, let alone in Realm Sphere. We move down to number 24. The cited video that the plaintiffs put in their initial lawsuit, the cited video speaks for itself. No response is required. Move down to 26. Averment 26 is a 15-paragraph recitation of statements made in the video cited in Averment 24. No response is required as the video speaks for itself. 27. The cited video speaks for itself. No response required. 28. Averment 28 is a 4-paragraph recitation of statements made in the video cited in Averment 27. No response is required as the video speaks for itself. 29 and 30, also the cited videos speak for itself, no response required. 31. Averment 31 is a 2-paragraph recitation of statements made in the video cited in Averment 30. No response is required as the video speaks for itself. 32, 33, similar. Number 34. After reasonable investigation, defendants cannot confirm or deny the averments in paragraph 34. By way of further answer, defendants have no ability to determine what Scott Miner was or was not aware of during any phone calls. Number 35. Averment 35 is from the plaintiffs. Averment 35, and this is our response. Averment 35 is grammatically poor and unable to be answered because it is not fully understood. To the extent it is required, Scott Minor consented and approved of the phone call once he answered the phone. Man. Okay, so we moved on 36 to 42. The video speaks for itself. 43. Averment 43 is a two-paragraph recitation of statements made in the video cited in Averment 42. No response is required as the video speaks for itself. 44. Cited video speaks for itself. 45. Averment 45 is a 7-paragraph recitation of statements made in the video cited in Averment 44. No response is required as the video speaks for itself. 46, very similar. 47, Averment 47 is a 5-page recitation of statements made in the video cited in Averment 46. No response is required as the video speaks for itself. 48, video speaks for itself. 49, Averment 49 is a 2-paragraph recitation of statements made in the video cited in Averment 48. No response is required as video speaks for itself. 50, video speaks for itself. 51, Averment 51 is a 6-paragraph recitation of statements made in the video cited in Averment 50. No response is required as the video speaks for itself, as in 52 as well. On 53, despite the fact that plaintiff incorrectly refers to the April 23rd video instead of the April 26th video, Averment 53 is a 5-paragraph recitation of statements made in the video cited in Averment 52. No response is required. 54, no response is required. 55, Averment 55 is a 6-paragraph recitation of statements made in the video cited in Averment 54. Video speaks for itself. Video speaks for itself. 56. 57 is a 5-paragraph recitation of statements made in the video cited in Averment 56. 58. After reasonable investigation, defendants cannot confirm nor deny the averments in paragraph 58. By way of further answer, defendants only alluded to Scott Minor's IP address to confirm that his computer was the IP address cyber stalking defendants' voices for voices website on a daily basis. 59. Admitted that defendants' voices have published videos alleging human trafficking. It is denied that these allegations were specific to the plaintiff. In fact, the statements made in regards to human trafficking focus almost exclusively on Brian Davis and Railmakers as opposed to the named plaintiff. 60. Admitted in part, denied in part. It is admitted that defendants have published videos. However, it is denied that any of the statements made in the videos produced by defendants contain any defamatory statements or false allegations. It is further denied that any statements were made in a threatening nature by defendants. In fact, all threatening statements made throughout the relationship of these parties has been made by plaintiffs and their cohort. 61, 62, video speaks for itself. Number 63. It is admitted that defendants produced videos with the stated hashtag, but defendants are confused as to the meaning of the rest of the averment, as these videos on TikTok are made public upon posting, not because of hashtags. 64. It is admitted that defendants made public safety concern tips to the Great Homeschool Convention, specifically about Brian Davis. 65. After reasonable investigation, defendants cannot confirm nor deny the averments in paragraph 65. To the extent of which an answer is required, it is admitted that realm makers frequently schedule conferences and may have scheduled one at the Davos Convention Center for July of 2025. 66. After reasonable investigation, defendants cannot confirm nor deny the averments in paragraph 66. To the extent to which an answer is required, it is admitted that the planning of conferences often requires considerable time, effort, and finances. 67. It is specifically denied that defendants have made false statements or done anything criminal with the intent of causing financial harm to plaintiffs. All publishing of truthful statements concerning members and activities of realm makers and realm spirit was done with the intent of speaking truth to power and to protect children. 68. Any reputational and or financial harm suffered by plaintiffs as a result of truthful statements being made about the organizations they run and the people they allow to control those organizations is their responsibility. The harm results from their actions and inactions, not from the truth being brought to the public. 69. After reasonable investigation, defendants cannot confirm or deny the averments in paragraph 69. Upon information and belief, it is averred that Brian Davis and Von Ullman are not only members of Realmakers and its affiliates, but they are in fact its leaders. 70. Plaintiffs' criminal records speak for themselves. No response is required. To the extent of which a response is required, having never been previously charged with crimes does not mean one did not commit a crime or is not currently committing a crime. Defendant is not alleging that plaintiffs have ever been charged with or investigated for child trafficking and related offenses. Only that realm makers and its affiliates should be investigated for and charged with human trafficking and related offenses. 71. Brian Davis criminal record speaks for itself. No response required. To the extent of which a response is required, having never previously have never been previously charged with crimes does not mean one did not commit a crime or is not currently committing a crime. Defendant is not alleging that Davis has ever been charged with or investigated for child trafficking or related offenses. Only that realm makers and its affiliates should be investigated and charged with human trafficking and related offenses. 72. Denied. Davis, referring to Brian Davis, has admitted to trafficking on multiple occasions, and Solomon has produced a documentation to plaintiffs of a human trafficking report made to Oregon City, along with the National Human Trafficking Hotline, case number 0136454-1. 73. After reasonable investigation, defendants cannot confirm nor deny the averments in paragraph 73. 74. Defendants speak for themselves. No response is required. To the extent a response is required, any reasonable person can opine that that silence and lack of response to claims of child trafficking can meet an admission of guilt. So what do you think so far? Pretty interesting, right? Okay. 75. Defendants incorporate their answers into averments 1 to 74 as if fully set forth herein. As the 78, any written or recorded speech made by defendants in relation to Scott Minor and or realm makers speaks for itself. No response required. 79. Averment 79 is a conclusion of law to which no response is required. To an extent which a response is required, the factual allegations in the averment are denied. It is specifically denied that defendants made or published any knowingly false statements or any statements that could be defined as defamatory. 80. Averment 80 is a conclusion of law to which no response is required. To the extent of which a response is required, the factual allegations are denied. It is specifically denied that defendants made or published any knowingly false statements or any statements that could be defined as defamatory. Averment number 81. Averment 81 is a conclusion of law to which no response is required. To the extent of which a response is required, the factual allegations are denied. It is specifically denied that defendants made or published any knowingly false statements or any statements that could be defined as defamatory. Further, it is denied that defendants possess any malice towards plaintiffs. They simply wanted to tell their true story. 82, conclusion of law to which no response is required. To the extent of which a response is required, the factual allegations in the averment are denied. It is specifically denied that defendants made or published any knowingly false statements or any statements that could be defined as defamatory. Any harm resulting to Scott Minor was brought on by his own actions in relation his own actions and inactions in relation to realm makers. 83. Conclusion of law to which no response is required. To the extent a response is required, the factual allegations in the averment are denied. It is specifically denied that defendants made or published any knowingly false statements or any statements that could be defined as defamatory. Any harm resulting to Scott Minor was brought on by his own actions and inactions in relation to realm makers. 84 is a conclusion of law to which no response is required. To the extent of which a response is required, the factual allegations in the averment are denied. It is specifically denied that defendants made or published any knowingly false statements or any statements that could be defined as defamatory. Any harm resulting to Scott Minor was brought on by his own actions and inactions in relation to realm makers. 85, this averment appears to be mistakenly made by plaintiffs in place of a prayer for relief. Wherefore, defendants respectfully demand judgment in their favor and against Scott Minor, along with an award of their attorney's fees and costs, as well as any further relief this court deems just. 86, 1 to 85, defendant incorporates its answer to averments 1 to 85 as if fully set forth herein. 87, conclusion of law, no response required. To the extent response is required, the factual allegations of the averment are denied. 88, the videos alluded to in averment 88 speak for themselves. No response is required. 89, any written or recorded speech made by defendants in relation to Scott Minor and or realm makers speaks for itself. No response is required. 90, averment 90 is a conclusion of law to which no response is required. To the extent a response is required, the factual allegations in the averment are denied. It is specifically denied that defendant made or published any knowingly false statements or any statements that could be defined as defamatory. 91, averment 91 is the conclusion of law to which no response is required. To the extent a response is required, the factual allegations in the averment are denied. It specifically denied that defendant made or published any knowingly false statements or any statements that could be defined as defamatory. 92. Averment 92 is a conclusion of law to which no response is required. To the extent which a response is required, the factual allegations in this averment are denied. It specifically denied that defendant made or published any knowingly false statements or any statements that could be defined as defamatory. Further, it is denied that that defendant possesses any malice towards plaintiff. It simply provided a platform for someone who wanted to tell their story. Averment 93. Averment 93 is a conclusion of law to which no response is required. To the extent which a response is required, the factual allegations in the averment are denied. It is specifically denied that defendant made or published any knowingly false statements or any statements that could be defined as defamatory. Any harm resulting to Scott Minor was brought on by his own actions and inactions in relation to realm makers. 94. Averment 94 is conclusion of law to which no response is required. To the extent which a response is required, the factual allegations in the averment are denied. It is specifically denied that defendant made or published any knowingly false statements or any statements that could be defined as defamatory. Any harm resulting to Scott Minor was brought on by his own actions and inactions in relation to realm makers. 95. Averment 95 is a conclusion of law, no response required. To the extent of which a response is required, the factual allegations in this averment are denied. It is specifically denied that defendant made or published any knowingly false statements or any statements that could be defined as defamatory. Any harm resulting to Scott Minor was brought on by his own actions and inactions in relation to realm makers. 96. Averment 96 is a conclusion of law to which no response is required. To the extent of which a response is required, the factual allegations in the averment are denied. It is specifically denied that defendant made or published any knowingly false statements or any statements that could be defined as defamatory. 97. Having fun? 97. Averment 97 is a conclusion of law to which no response is required. To the extent of which a response is required, the factual allegations to the averment are denied, as there was no tortious conduct by defendant or its agent. 98. Averment 98 is a conclusion of law which no response is required. To the extent of which a response is required, the factual allegations in the averment are denied. It is specifically denied that defendant made or published any knowingly false statements or any statements that could be defined as defamatory. 99 says the 100. 100. This averment, as well as averment 99, appear to be mistakenly made by plaintiffs in place of a prayer for relief. Wherefore, defendant respectfully demands judgment in its favor and against Scott Minor, along with an award of their attorney's fees and costs, as well as any further relief this court deems just. Violation of the Pennsylvania Wiretapping and Electronic Surveillance Control Act. Scott Minor versus Voices for Voices and Solomon. Number 101. Defendants incorporate their answers to averment 1 to 100 as if fully set forth herein. 102. Averment 102 is a conclusion of law to which no response is required. To an extent response is required, Factual allegations in the averment are denied. 103, averment 103 is conclusion of law to which no response is required. To the extent of which a response is required, factual allegations are denied. 104, 104, averment 104 is a conclusion of law to which no response is required. To the extent a response is required, factual allegations in the averment are denied. Further, the one conversation plaintiff is referring to was recorded, if at all, by a party not named to this lawsuit and persisted long after plaintiff was alerted to the fact that the call was being recorded and thereby resulting in his consent. 105. Averment 105 is a conclusion of law to which no response is required. To the extent of which a response is required, factual allegations to the averment are denied. 106 is a conclusion of law, no response required. Extent which a response is required, factual allegations in the averment are denied. 107, averment 107 appears to be mistakenly made by plaintiff in place of a prayer for relief. Wherefore, defendants respectfully demand judgment in their favor and against Scott Minor, along with an award of their attorney's fees and costs, as well as further relief this court deemed just. Commercial disparagement 108. Defendants incorporate their answers to averments 1 to 108 as if fully set forth herein. 109 is a conclusion of law to which no response is required. To the extent which a response is required, the factual allegations in the averment are denied. It is specifically denied that defendants made or published any knowingly false statements or any statements that could be defined as defamatory. 110, the video alluded to in averment 110, speak for themselves, no response required. 111, any written or recorded speech made by defendants in relation to Scott Minor and or realm makers speaks for itself. No response is required. 112 is conclusion of law to which no response is required. To the extent which a response is required, their factual allegations, the factual allegations to the averment are denied. It is specifically denied that defendants made or published any knowingly false statements or any statements that could be defined as defamatory. 113 is a conclusion of law, no response is required. To the extent which a response is required, the factual allegations in the averment are denied. It is specifically denied that the defendants made or published any knowingly false statements or any statements that could be defined as defamatory. 114. 114, averment 114 is a conclusion of law, no response is required. To the extent which a response is required, the factual allegations in the averment are denied. It is specifically denied that defendants made or published any knowingly false statements or any statements that could be defined as defamatory. Further, it is denied that defendants possess any malice towards plaintiffs. 115, denied. Defendant's sole intent was to tell the truth and protect others from the fate Solomon experienced at the hands of realm makers and its affiliates. 116, admitted in part, denied in part. It is admitted that defendants have used the hashtag boycott realm makers. It is denied that defendants' intent was to cause financial harm, but to rather tell the truth. 117. 117 is a conclusion of law to which no response is required. To which one a response is required, the factual allegations in the averment are denied. It is specifically denied that defendant made or published any knowingly false statements or any statements that could be defined as defamatory. Any harm resulting in plaintiff was brought on by his own actions and inactions of those in leadership positions at realm makers. Averment 118 is conclusion of law. No response is required. To the extent which a response is required, the factual allegations in the averment are denied. It is specifically denied that defendants made or published any knowingly false statements. Wherefore, defendants respectfully demand judgment in their favor and against plaintiff. along with an award of their attorney's fees and costs, as well as any further relief this court deems just. Injunctive relief 119. Defendants incorporate their answers to adjournments 1 to 118 as if fully set forth herein. 120. Admitted that publications referencing Realmakers and its affiliates still exist on Voices for Voices, social media pages, and channels. It is denied that any of these publications contain defamatory statements. Rather, they contain the truth. 121. The videos published by defendants speak for themselves. No response is required. 122. It's admitted that defendants intend to continue to speak the truth and to try to protect others from the same fate as Solomon. 123. It is admitted that defendants have spoken about Solomon's experiences with Realmakers in the lead up to their Grand Rapids conference in order to try to protect others from the same fate as Solomon. You take a breath here. Wow. 124. Averment 124 is a conclusion of law to which no response is required. To the extent of which a response is required, the factual allegations in the averment are denied. 125, same. 126, same. 127, averment 127 is a conclusion of law to which no response is required. To the extent which response is required, the factual allegations in the averment are denied. All statements made or published by defendants were based on the personal experience of defendant Solomon concerning his time in Realmakers. 128. Plaintiff cannot seek injunctive relief prohibiting these truthful statements. 129. Averment 129 is a conclusion of law to which no response is required. To the extent a response is required, the factual allegations in the averment are denied. 130 is a conclusion of law to which no response is required. To the extent of which a response is required, the factual allegations in the averment are denied. 131. Averment 131 is a conclusion of law to which no response is required. To the extent which a response is required, the factual allegations in the averment are denied. 132. 132 is conclusion of law to which no response is required. To the extent the response is required, the factual allegations in the averment are denied. Same for 133. Wherefore, defendants respectfully demand judgment in their favor and against plaintiff, along with an award of their attorneys' fees and costs, as well as any further relief this court deems just. New matter 134. Defendants incorporate their answers to averments 1 to 133 as if fully set forth herein. 135. Truth is an absolute defense to defamation. Let me say it again. 135. Truth is an absolute defense to defamation. 136. Plaintiff's claims are barred by the doctrine of fraud and or illegality. 137. Plaintiff's claims are barred by the doctrine of duress. 138. Plaintiffs have suffered no compensable damages. 139. Plaintiffs do not have capacity to sue or bring this action, and this action is therefore barred. 140. Plaintiffs' claims are barred by the statute of frauds, lashes, unclean hands, and or the statute of limitations. 141. Defendants did not breach any duty owed to plaintiffs. 142. Plaintiff's claim may be barred by the doctrine of res judicata, waiver, or estoppel. 143. Plaintiff's own conduct may bar any recovery made against defendants. 144. Plaintiff's damages, if any, are the result in whole or in part of his own actions and contributory fault. 145. Defendants incorporate by reference the new matter set forth in PA.R.CIV.P.1030, in particular 1030A, truth and required by PA.R.CIV.P.1032 to the extent that those defenses are applicable. 146. Defendants reserve the right to assert additional defenses upon discovery of evidence that may support those defenses. Counterclaim of David Solomon. Facts. 147. Solomon incorporates answers to averments 100 to 145 as if fully set forth herein. 148. On January 12, 2012, Solomon was taken from the custody of his mother against his will and without his mother's permission. 149. At that time, Solomon's legal name was Nathaniel Isaac Hune. 150. Solomon's mother had cancer. She was being administered chemotherapy treatment and had been given approximately 3 months to live. 151. Solomon and his mother received a message from Brian Davis asking them if they would like someone to come pray with them. Solomon's mother said no, but Brian Davis and others came anyway. 152. Brian Davis, Jamesville, and Shilohville arrived at the Berry Hill apartments in Oregon City, Oregon, where Solomon and his mother resided, and proceeded to place a chloroform laced rag on David's mouth, causing him to black out. 153. The next memory Solomon has, he was in Grants Pass, Oregon, where he was taken in a white van. 154. Brian Davis held himself out to be the leader of, in quotes, Holy Worlds, which was the community and website that is now known as Realm Makers, which is run by Faith and Fantasy Alliance LLC. 155. Brian Davis forced Solomon into sex slavery and involuntary servitude in and around Willamette, Oregon from 2012 until 2023. 156. Amongst many other acts, Brian Davis forced Solomon to engage in sexual intercourse with a teenager under the age of 18 and videotaped it to hold as leverage over Solomon for years to come. 157. The involuntary servitude is related to Brian Davis forcing Solomon to write fictional religious stories, which Faith and Fantasy Alliance LLC profited from. 158. During this time, Brian Davis also legally changed Solomon's name from Nathaniel Isaac Hune to his current name of Solomon O. David Soldier. Brian Davis used this name to openly mock Solomon, as the initials are S period O period S period, aka Save Our Souls. He did so on or about January 16th, 2012, and without Solomon's knowledge. 159. Solomon met plaintiff Rebecca Minor on Holy Worlds sometime in 2009 through their writing on the site. He did not know Scott Minor throughout this time period. 160. In or about October 2023, Solomon was using Realmakers to network with the other members and writers to get his new writing out. 161. Scott Minor reached out to Solomon stating that he never saw anyone network as successfully on the platform as Solomon had, and that he wanted to talk with him. 162. Solomon and Scott Minor became good friends for that year from October 2023 until October 2024, with Scott Minor even asking Solomon to become a leader of Realm Makers. 163. It was at this point when Solomon was asked to become a leader that he finally decided to tell Scott Miner about Brian Davis and everything that had happened to him over the past 12 years. 164. Solomon was still very hesitant to divulge everything he had been through, and even prayed about it for 2 whole days before confiding in Scott Miner. 165. Without divulging all that happened to him, and while trying to be slightly vague and careful, Solomon explained that one of the leaders of realm makers was trafficking and abusing children and using the platform to do so. 166. Scott Miner asked who the person was, and while Solomon was hesitant to say, he did divulge that it was Brian Davis because his ultimate goal was to have Scott Miner, as the actual leader of realm makers, investigate Brian. 167. Solomon further explained that he was not telling his story in order to have Brian Davis arrested, but rather so he could help clean up the platform he was being asked to be one of the leaders of. 168. Solomon went to other members of Realm also to share his story with the same intent. 169. Scott Miner seemed interested in Solomon's story and made clear that he would investigate the claims and Brian Davis' involvement in Realm Makers. He asked for Solomon and his wife Amanda to produce evidence they had related to Solomon's story. 170. On October 18th, 2024, Solomon and his wife Amanda began to produce evidence in the form of police reports, texts, emails, and screenshots, and were met with a strange response from Scott Miner. For unbeknownst reasons, Scott Miner demanded that all of the rest of the evidence Solomon and his wife Amanda had be had to be sent to him within 24 hours. 171. After approximately 12 hours from the time Scott Miner requested the follow-up evidence, he chose to delete both Solomon and his wife Amanda's accounts from the Realmmakers platform. 172. The only reason provided for the deletion of these accounts was that Scott Miner accused Amanda of falsifying information. He provided no reason to Solomon. 173. Furthermore, Solomon's 9-year-old son, who also had a writing account on Realmmakers, also had his account deleted at the same time. 174. It is believed and therefore averred that Scott Miner, in fact, never investigated the claims made by Solomon. 175. It is believed and therefore averred that Scott Miner, in fact, knew what Brian Davis did to Solomon and other children, and either supported it, requested it, or helped hide it. Count 1, human trafficking. 18 PA CONS STAT statute looks like 3051. I'm not a legal eagle, so I'm not sure what the symbol means. I think it means statute. David Solomon versus Faith and Fantasy Alliance, LLC, Scott Miner and Rebecca Miner. 176. An individual who is a victim of human trafficking may bring a civil action against any person that participated in the human trafficking of the individual in the court of common pleas of the county where the individual resides or where any of the alleged violations of this chapter occurred. 177. These claims may be brought against individuals who recruited, profited from, or maintained the victim in any sex trade act, or who abused or caused bodily harm to the victim in any sex trade act. 178. While the human trafficking alleged herein took place in Oregon, the plaintiffs in underlying civil action brought suit in Montgomery County, PA. Therefore, in the interest of all parties, Solomon brings his claims of human trafficking as the counterclaim plaintiff in the same county. 179. 18 PA CONS STAT 3051 defines, quote, victim of the sex trade, quote, end quote, as an individual who has one, been the object of a solicitation for prostitution, two, been the object of a transaction in a sex act, three, been intended or compelled to engage in an act of prostitution, four, been intended or compelled to engage in a sex act, five, been described or depicted in material that advertises an intent or compulsion to engage in sex acts, or six, in the case of obscenity or child sexual abuse material, appeared in or been described or depicted in the offending conduct or material. 180. Under the definition laid out in Amendment 177, Solomon was a victim of the sex trade. 181. Solomon was forced by Brian Davis to be the object of solicitation for prostitution. 182. Solomon was the object of a transaction in a sex act forced by Brian Davis. 183. Solomon was compelled to engage in an act of prostitution on multiple occasions, both with adults and minors. 184. Solomon was compelled to engage in sex acts on multiple occasions, both with adults and minors. 185. Solomon was coerced and forced by Brian Davis to appear in child sexual assault material showing offending conduct with a minor. 186. Brian Davis, Jamesville, and Shilohville were the individuals responsible for trafficking and holding Solomon as a victim of the sex trade. 187. It is believed and therefore averred that Brian Davis, Jamesville, Shilohville were not only members of realm makers, but leaders of it. 188. Brian Davis, in fact, held himself out publicly as one of the leaders of realm makers. 189. Brian Davis, Jamesville, and Shilohville trafficked and held Solomon as a victim of the sex trade in furtherance of the goals of realm makers, which is a platform owned and operated by Faith and Fantasy Alliance LLC. 190. It is believed and therefore averred that Faith and Fantasy Alliance LLC guided Brian Davis in recruiting Solomon as a victim of the sex trade. 191. In the alternative, if Faith Fantasy Alliance LLC did not guide Brian Davis' actions in trafficking Solomon into the sex trade, it did in fact profit off of it through Solomon's fictitious religious writings he was forced to draft as an involuntary servant. 192. It is believed and therefore averred that Scott Minor and Rebecca Minor did, in fact, know and direct Brian Davis' actions in relation to Solomon. 193. In the alternative, if Scott Minor and Rebecca Minor uh, did not in fact know and or direct Brian Davis' actions in relation to Solomon, they did profit off of these despicable actions. 194. Furthermore, if Scott Minor and if furthermore, if Scott Minor and Rebecca Minor did not in fact know and or direct Brian Davis' actions in relation to Solomon, they failed to investigate claims brought by Solomon in 2024 and instead sued him for defamation. 195, 18 PA CONS statute 3051D requires that a prevailing plaintiff who is a victim of human trafficking be awarded reasonable attorney fees and costs. 196, 18 PA CONS statute 3051E requires treble damages to be awarded to a victim of human trafficking on proof of actual damages where the defendant's acts were willful and malicious. Wherefore, counterclaim plaintiff respectfully demands judgment in his favor and against plaintiff, along with an award of his attorney fees and costs, an award of treble damages as required in the statute, as well as any further relief this court deems just. And that, my friends, is our legal response to Faith Fantasy and Alliance LLC, aka Realm Makers, aka leader Scott Miner, Rebecca Miner. And while I tried to read verbatim everything quote, uh, there were areas that I may have missed a word, put the words together. But what this does is it proves that Faith Fantasy and Alliance LLC, aka Realm Makers, aka Realmster, aka Scott Miner, Rebecca Miner, uh, they're suing a charity, which is us, Voices for Voices, and a human trafficking survivor, David Solomon. And I took all that time reading through that, getting out of breath because it's a lot. Uh, because it's important to share with the 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 public because we want to be transparent. We want to share the facts. We want to share as much as we can and as much real time as we can. And these are public documents, and you're able to find these on the docket. And so now, after this response, we get word of impending depositions of Voices for Voices, David Solomon, Amanda Solomon. Again, remember, right? We're a charity. We share information, especially public safety concerns, public health. Uh, we give a platform to tell a story as as they remember, as as they remember and believe in good faith to be true. Uh, and and again, we live in the United States of America, and we do have the First Amendment, and that's called freedom of speech. So we just wanted to share that with you. I uh, I don't apologize for doing that because that was the only way to get this out in the open and out from the shadows of what looks to be what's happening, where we want things hush hush. We don't want to talk about it. Well, we're talking about it, and we ask for your support, both emotionally, spiritually, but we also ask for it monetarily at this time because attorney fees uh, are just that, they're attorney fees. And we have a human trafficking survivor that's been by all means had 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 his career just taken away. And you have a charity we've interviewed all walks of people from all walks of life. And so what we just shared in this probably hour plus uh, time is, again, this is our response. This is our legal response, but it's also public knowledge. It's on the docket, but we don't want to tell anybody though. We just we'll just keep it on the down low. Not anymore. It's not on the down low anymore. So we do ask organization for monetary support as we navigate these waters, because I'm a firm believer, as a lot of individuals are, that the truth will prevail, that everything we do is in God's hands, and we're trying to help people. So if you're able to donate, head on over to Venmo, Voices, the number 4 Voices, or head over to our website, Voices 4, which is this time the 4 is spelled out. So FOR voices.org. That is voices for voices.org. And the top middle, you'll find a spot, support the show, support the organization. And we are, again, as mentioned, we are a 501(c)(3) nonprofit. And so all donations are indeed, in fact, 100% tax deductible. So please share this. Please share this. Please repost. Please like, share, follow, subscribe, give us big thumbs up. Help us get the word out. This is a time that uh, we really could use a little boost monetarily uh, to to go forward, to again keep speaking the truth. You know, we love you. We love your support. Uh, Another way you can support us is to head on over to Amazon, and we have a couple pamphlets, short books. One is called The House of You Prescription for Living, and that's all about my mental health journey. And then we also have The House of You 5 Workforce Preparation Tips for a Successful Career. And so I'm going to try to, okay, virtual background. I'm going to show you what the covers look like. So as you go over there, you know. So this one right here, this is The House of You Prescription for Living, details my mental health crisis, and the way I started to regroup. And then this one, The House of You 5 Workforce Preparation Tips for a Successful Career. If you or anybody is getting ready to graduate, uh, looking for a new role, just looking to update your resume, uh, or just brush up on some areas, and uh, behind if you can, I mean, it would be helpful if you would pay it forward too. So it's not only what you know and what can help you, but it can pay it forward to others as they start their workforce journey, whether they go to college, whether they go to trade school, uh, whether they're an entrepreneur, doesn't matter. Personal branding, for example, one of the topics covered, everybody has a personal brand. You know, everything we do from the time we wake up to the time we go to sleep and all that becomes personal branding where we're able to talk about things that we have done and what makes us who we are and how we can be an asset to a deal, to an organization, uh, and so much more. And then the mental health story, that's me just again just being transparent, talking about hard things, talking about very sensitive topics. Mental health, very very sensitive, and it's hard to talk about. It's exhausting to talk about, but it's important also to talk about. So again, if you head over to Venmo, help us out. Voices, the number four, voices all together, or head over to voices4voices.org. This time with the four spelled out, FOR. Uh, and any little bit will help. Again, if you can give us a big thumbs up, like, share, follow, subscribe, comment, we love you. God bless you. God bless everybody in the entire world and in heaven. And God bless us in the United States of America and anybody who is going through a rough patch. Things will get better. You're meant to live, and you're meant uh, to do great things. And I know this from experience of being feeling down and out so many times, so many times. So don't give up on yourself. I'm not giving up on you. People love you. We love you. And we're just grateful for you hanging around, watching, listening. And again, let's blow this episode up. Let's let's help those 3 billion people. So until next time, I'm Justin Allen Hayes, founder of Voices for Voices. Please be a voice for you or somebody in need, and let's celebrate all voices. We'll see you next time on the